Welcome to Stira IAS Academy in this Unacademy platform. My name is Lala Ignatius. I am going to handle the polity part now. On the basis of that, I want to discuss about the topic regarding the various differences between the bill like ordinary and the constitutional amendment bill, or else we can say that money bill and finance bill 1 and 2. This is the topic only I am going to make. And while going for that the students who want to join into this UPSC courses with the help of Sriram's IAS code. So you can able to get some 25 percentage concession from the main fees, and apart from that some more other facilities like you can able to avail our end-to-end process completely at your doorstep, and various other the structured courses and live courses, all the things will be available for the students. Okay, various foundational course and crash course and other things we already started, and we are going to start, so you can also able to get the facility at your doorstep. Okay, good. Now I'm going to start the topic like the comparison of the bills regarding starting from ordinary and money bill and finance bill 1 2 and 2 type. Then finally I will go into the consideration of the concept regarding constitutional amendment bill separately. So now the case is that this is the part most complicated part into the nature of budget process. And the second important thing is that the students are having a lot of confusion whenever we are discussing in this topic in our classes. The way generally the students also asking a lot of questions. On the basis of that, I can able to understand on the basis of my experience that students are having some difficulty to go into this nature, because when I want to talk about money bill under Article 110 of the Indian Constitution, I can clearly say that. So this is the process. On the basis of that, the way how the things regarding money bill, for example, money bill in the sense that under Article 110 of the Indian Constitution, people can able to say that the money bill is an idea exclusively in the hands of the Speaker of the House. Speaker is an ultimate authority. On the basis of that, whatever the provisions regarding money bill, that will be decided. That like that manner. When I want to talk about an ordinary bill, some kind of exclusive nature the ordinary bills are having. Okay, when I want to talk about the finance bill 1 and finance bill 2, and under the procedures of article 1171 and 1173, this is otherwise called as finance bill A type and finance bill B type. So the general notion when I'm going to start with an idea of money bill, under article 110, people can able to come for the conclusion that there are the financial things or the economic part or money kind of things are involving into, and all those money kind of things are come under the category of money bill as per the certification of the Speaker of the House. And Speaker is an ultimate authority who can able to give certain bill as a money bill or not money bill. Even it is his exclusive power, and court cannot able to interfere into this activity. So in this nature, when I want to talk about the ideas of money bill under Article 110, this is a very vague and very, very common term. So we need to go for a classification that what are the areas that are coming under Article 110, and related to this idea, anything regarding the imposition and abolition and regulation or alteration or remission of any tax. That's the first foremost important thing, the tax. When we are going to talk about the tax provision, any changes inside the taxes will come under the category of money bill. And the second important thing, the way how the government, in order to generate revenue, and this revenue and expenditure part, when I want to discuss about it in the revenue area, it is not only in the name of taxation process, the government also can able to go for the borrowing methods, borrow of government of India. On the basis of that, the regulation or borrowing of money by the government of India from the various sources will also come under the category of Article 110 of the Indian Constitution in the name of money. And other than that, the way how the payment of money into or the withdrawal of money from the consolidated fund of India. I am going to make some kind of payment into or withdrawal from the consolidated fund of India, that I'm sorry, that is also will come under the nature of money bill. And other than that, when we are going to declare a matter, a new item into the category of expenditure charged from Consolidated Fund of India. What are the expenditure charged from Consolidated Fund of India? That will also come under the category of money bill under Article 110. And another, other than that, any general matter, any matter incidental to any of the matters specified under Article 110, one subclause and other various subclasses to A to F, all will come under the category of money bill. So the most important thing I want to repeat it again, when I want to discuss about what is money bill under Article 110, I can able to say that taxation method and regulation and imposition and abolition or remission and declare changes, alteration, anything regarding to taxation will come under Article 110 as a money bill. Our second thing is that the borrowings of the government will come under Article 110 as a money bill, and any payment of money or the withdrawal from the Consolidated Fund of India will come under the category of money bill. And the way how the declaration of the new items into the category of expenditure from the Consolidated Fund of India charged on the Consolidated Fund of India will come under the category of money bill. Here students might be aware of this point, that when I want to look into this idea of money bill or the charged items expenditure Consolidated Fund of India, two way we can able to make expenditure, that is in expenditure made from Consolidated Fund of India, expenditure charged from Consolidated Fund of India. In this charged items, it won't go for parliamentary votings, and made from Consolidated Fund of India, it will go for debate, discussion, and finally voting also. But in charged items, only debate and discussion, not in the category of voting right of parliamentary. This is the way the expenditure, the Consolidated Fund of India, the way how you are going to take money as a part of money bill or finance bill will come under the category of charged from Consolidated Fund of India, made from Consolidated Fund of India. So when I want to compare the ordinary, the financial and other various bills regarding parliamentary proceedings under Article 107, I can able to say this is money bill. And under 110 of the Indian Constitution, I can able to make it as a finance money bill. And 117 first class subclass, I can able to say finance bill A type. And 1173, I can able to make a differentiation in the name of finance bill 2 type. And after this introduction, a person can also ask something regarding how the way, what is the difference between finance bill, how the way it is going to differ from money bill. So in this category, when I want to look a finance bill in a very general nature, so I can able to come into the category of any bill which relates to the matter of revenue or expenditure. Simple way. Any bill which is related to the part of revenue or expenditure will come under the category of Article 171 class and 1733 class in the name of Finance Bill first type and Finance Bill second type. Okay, so this is a general idea. Other than the provisions mentioned in Article 110 regarding taxation, borrowing, and Consolidated Fund of India, and any classes under 110, starting from A to F, under 110, one of the Indian Constitution will come under money bill, and any matter regarding revenue and expenditure will come under the category of Finance Bill 1 type and 2 type. And ordinary bill means all a bill will be recommended by the Speaker of the House in the name of ordinary bill will come into the nature of under Article 17 or 107 of the Indian Constitution as money, ordinary bill. Okay. Now, second important thing, the way how we are going to introduce the bill, there is a differentiation. Ordinary bill can be introduced in either house of Lok Sabha or Rajya Sabha. No issue. You can able to introduce in any houses. Since money bills are very most important thing, and Lok Sabha is having some kind of authority, the way how Speaker of the House can able to decide the matters regarding money bill. In this nature, money bill only introduced inside Lok Sabha. Money bill only introduced inside Lok Sabha. And in the same way, when I want to look into the idea of finance bill, is also having similarity with the money bill, and finance bill one type also only introduced inside Lok Sabha. These are the area not at asked by USC in preliminary area. So anytime you can able to expect these type of questions when you are going to look into the nature of the difference between money bill or finance bill or ordinary bill or constitutional amendment. So ordinary bill can be introduced in either house of Lok Sabha and Rajya Sabha. Money bill can be introduced only in Lok Sabha, and finance bill one type under 1171 of the Indian Constitution can be introduced only in Lok Sabha. Like ordinary bill, finance bill two type can also able to introduce in either house under 1173 of the Indian Constitution. This is another important thing we need to go into the consideration. Then, when I'm moving further, the second most important distinction I can able to make, the ordinary bill can be introduced by either a minister or a private member. If any member of parliament other than the council of ministers tries to introduce a bill, he may be a ruling party or opposition party. That bill will be considered as a private member bill. If the council of minister want to introduce any bill, that will come under the government bill. So that is the classification regarding private member and the government bill. So ordinary bill can be introduced either by a minister or a private member, a member of parliament. Private member means a member of parliament. But money bill, when you want to take under 110 of the Indian Constitution, can be introduced only by a minister. This is another most important thing. Money bill can able to introduced only by the ministers. Only by the ministers you can able to say. Okay. And the second most important thing, like the way like any ordinary bill, finance bill one type and two type, in both the cases, it can be introduced either by a minister or a private member, either by a minister or a private member. So this is the case like a ordinary bill, either a minister or a private member, anybody can able to introduce the ordinary bill, finance bill one type and finance bill two type. But only one difference I can able to say, like money bill, finance bill one type also introduced only in Lok Sabha. This is the only comparison similarity we can able to make when I want to discuss about money bill with finance bill, a type of the Indian Constitution. Fine. Then when I'm moving further, when I want to introduce an ordinary bill, so there is no prior recommendation of the President of India is necessary at the time of its introduction. So President, when it is going for his assent, he can stop the bill, he can withhold the bill, he can reconsider the bill. Like that manner, he can able to use all his veto power related to ordinary bill. But when the matter is regarding money bill, at the time of the introduction of the money bill, after the certification from the speaker as money bill under 110 of the Indian Constitution, then only it is necessary that before the induction of the bill as a money bill, the prior recommendation of the president is very much necessary. The previous consent of the president is very much necessary when you are going to look into this matter of the concept like money bill. So previous recommendation of the presidents are very necessary while going to introduction of the ideas of money bill. And when I'm going to the finance bill one type, like the way how it only introduced in Lok Sabha money bill and finance bill one type also only introduced in Lok Sabha. So in this case, like money bill, need of the previous recommendation of the president for its introduction. Here also finance bill one type and two type. In two way I can able to say finance bill one type and money bill have the similarity. Money bill only introduced in Lok Sabha, finance bill A type only introduced in Lok Sabha. Money bill before its recommendation, before its introduction, president's recommendations are necessary. Finance bill one type before its introduction, president's recommendations are necessary. And like ordinary bill, the finance bill two type, no need of recommendation of the president before its introduction. Before its introduction. And the most important part I want to mention here, ordinary bill, I said like a finance bill two type, no previous recommendation of president is necessary for the ordinary bill. So president can able to use his veto power in an enormous manner related to money bill. Sorry, ordinary bill. But the most important thing, there is an exception inside our Indian Constitution. When we are going to do something in the name of Article 3 of the Indian Constitution regarding the formation of the states alteration of its boundary, changing nature of the state, anything in the name of the alteration may come into the category of under Article 3 of the Indian Constitution, then we can consider is a state reorganization bill. State reorganization bill. And this state reorganization bill is considered as an ordinary bill only. But while doing so, there is an only one exception in our Indian parliamentary proceedings. All the ordinary bills, no need of president's recommendation before its introduction, at the time of its introductions. But only a ordinary bill, state reorganization bill under Article 3 of the Indian Constitution, when it's going to introduce inside the House and with the recommendation of the President only, this ordinary bill, state reorganization bill, need to be introduced inside the Parliament. That is an exclusive exception we can able to provide to the idea of ordinary bill. All the ordinary bill will come without the recommendation of the President, except the state reorganization bill. It will come with the recommendation of the President, like money bill or finance bill one time. And the second next important thing is that when the ordinary bill go to the next house after passing the first house, the house where we are initiating, and the second house can able to amend the ordinary bill, can reject the ordinary bill. In two ways the process will happen. The second house can able to amend the ordinary bill, also reject the ordinary bill. And in money bill, the second house can able to hold. That is only one important things. Okay, the second house has to give his recommendation and they cannot amend or reject it. They can able to give a recommendation regarding money bill. Okay, but they cannot able to amend the money bill. They cannot able to reject the money bill. This is the category in money bill under 110 of the Indian Constitution. But here afterward, finance bill 1 type and 2 type almost in similar category with the ordinary bill only. When the matter regarding finance bill, second house can able to amend or reject the bill like ordinary bill. The finance bill 2 type also, the second house can able to amend and reject the finance bill 2 type under 117 and 3 class of Indian Constitution. So this is a varying point, that money bill, the second house has much authority. Only in ordinary bills, finance bill 1 type and 2 type, the second house has this variation. So based on that, once the second house reject an ordinary bill, finance bill 1 type and 2 type, that will lead to the character of deadlock that I will explain later. Then when I'm moving to the next level, that the ordinary bill, finance bill 1 type and finance bill 2 type, all in similar category. So I can able to explain in simple terms, the second house can able to hold ordinary bill. The most important thing, the second house can able to hold ordinary bill for the category of 6 months. And at the end of the 6th month, it will be considered as a deadlock. And automatically once a house not able to proceed with a passage of ordinary bill or finance bill 1 type and 2 type after 6 months, it will be considered as a deadlock, and the deadlock can be resolved with the help of the way how the president is going to call for joint sitting. This is second point. The president can able to call for joint sitting, and joint sitting will be presided by the speaker of the house. So this is another most important thing when you are going to look into this idea. And the way how the deadlock is going to resolve, there is no role of vice president of the house or the ex-officio chairman of Rajya Sabha. Only the deadlock will be resolved by the joint sitting headed by the speaker of the house, and president only can able to call for this kind of joint sitting. And there is another term, joint session. Every year, 1st January, first week, when the assembly is going to meet and the president of the house will come before, jointly give some kind of speeches every year, and after every general election, the first meeting, there the president will come and give his speeches. That is considered as the matter of joint session of the parliament under 86 and 87 of the Indian Constitution. But here the matter is that when there is a deadlock regarding ordinary bill, finance bill 1 type and two type, and that deadlock can be able to resolve with the help of the way how the president can able to call for joint sitting, and that sitting will be presided by the speaker, and combination of Lok Sabha and Rajya Sabha voting will be happen, and majority will be proven. On the basis of that, the deadlock will be removed and the bill will be passed and go to the president's assent. Once it get the assent of the president, every bill will become act. Money bill, finance bill, all will become act. Financial Act 2023, for example, the ordinary bill related to some act, that will become act only after getting the consideration assent of the president of India only. And here there may be a possibility UPSC never asked any question related to this point. When the matter is related to the president's concern, and once he give his assent, any bill will become act. But when it come into force, enactment of the constitution happened in 26th November 1949. When constitution came into force, commencement of the constitution came into force from 26th January 1950 onwards. The same way, when president gave his assent, if a bill won't become act or act won't become implemented inside the country, the act, once it is entered into the Gazette of India, that is another important thing. The act once entered into the Gazette of India, okay, once it is entered, published inside the Gazette of India, that act will come into force. So now UPSC may ask a question from here. So which ministry is handling the Gazette of India? People may have a general idea that Parliamentary Affairs Ministry, or people may have an idea like Law Ministry, or the Ministry of Information and Broadcasting, something like that. But the real answer is that any act, once it is published inside the Gazette, it will come into force. Implementation of those acts will come into force. But the most important part, the Gazette of India is managed by the Ministry of Housing and Urban Affairs only, not under the category of Parliamentary or Information or other various ministry, only under the Ministry of Housing as well as the areas of urban development. So in this manner only there is a uniqueness. This part not at asked by any UPSC examination. Anytime it may come. But when the matter regarding money bill, the second house doesn't have any authority except a recommendation. It cannot be able to reject or amend. So 14 days the second house can able to hold the money bill, and 15th day automatically that bill passed inside Rajya Sabha we will consider, and it will go to the president's assent. This is a category we can able to say when it is related to money bill kind of things. Okay, good. Then when I'm moving further, there are some more ideas we have to keep it separate. Like ordinary bill I mentioned under 107, money bill under 110, and finance bill 1 and 2, 3 under the category of 1171 class and 1173 class. But there is a provision under Article 368 in the name of Constitutional Amendment Bill. These are all the 5 bills are existing. One is ordinary bill, second one is money bill, third one is finance bill or finance bill 1 and 2, and the fourth or fifth type is considered as a constitutional amendment bill. So here the constitutional amendment bill, like ordinary bill, may be initiated by introduction of a bill, under the category of, just a second, under the category of either house of the parliament. So a constitutional amendment bill can be introduced in either house of the parliament. First important point. And second important point, that bill again may be introduced by, this is the most important thing, may be introduced by a government or private member. If it is government, a council of minister, or if it is private member, any member of parliament other than the council of minister will come under the category of private member. So constitutional amendment bill introduced in either house, Lok Sabha and Rajya Sabha, and the most important thing, introduced by a council of minister or a private member, like any ordinary bill or finance bill 2 type or something like that. And second most important thing, generally in Indian purpose, constitutional amendment only introduced by the council of ministers, general. but some kind of exemption. But when the matter, a constitutional amendment bill initiated by a private member, and there should be some kind of methodology. On once a constitutional amendment introduced by a private member, and that bill will go to the committee on private members' bills and resolution. And the way how the examination and the recommendation for the introduction in the House in a bill initiated by the private member related to the constitutional amendment bill will go to the committee on private members bills and resolution, and the private member committee will completely examine and recommend it. After their examination and recommendation only, a private member constitutional amendment bill will be initiated inside the houses. So the scrutiny of the committee on private members' bills and resolution will be upon the constitutional amendment bill initiated by a private member. And when you are going to look into this idea, this type already asked by UPSC a few years ago. Ordinary bill, either house. Finance bill 2 type, either house. And when there is a problem after 6 months, the deadlock and all those kind of provision we discussed already. But when I am going to look into the matter of constitutional amendment bill, the most important thing, there is no provision we can able to make the concept of constitutional amendment bill into the nature of joint sitting. So you cannot able to go into the nature of a deadlock into the nature of constitutional amendment bill. We don't keep the joint sitting for resolving the deadlock related to amendment bill. So no joint sitting for constitutional amendment bill for regarding. And the another necessary point is that when you are going to look into this matter, the president must give his assent to the bill. This is another most important thing. The president of India definitely and must give his assent to the bill of constitutional amendment. He cannot able to use his veto power related to the constitutional amendment bill. This is another most important thing. The president of India must give his assent to the constitutional amendment bill. This is another important thing. Okay, and apart from this, there are some kind of general concept people will say when the constitutional amendment bill under article 368, when it is going to implement inside the parliament into the nature of passage of the amendment bill, will come under the category of a simple majority based amendment bill or simple majority based amendment bill, and other than that amendment by a special majority, and amendment by a special majority and ratification of the half of the state is also necessary. In this three classification and three category, we can able to make the concept of constitutional amendment bill under the article 368. So what are the provisions will come under the category of ordinary constitutional amendment bill, a simple majority based constitutional amendment bill? And here I can able to say already we discussed a matters regarding the admission and establishment of the formation of the state will come under the nature of the constitutional amendment bill with simple majority, article 234. Everything will come under the category of simple majority constitutional amendment bill. And abolition of legislative council in a state under 169 will come under the category of simple. And admission and control of scheduled areas and scheduled tribes under the fifth schedule will come under the category of this particular area of simple bill. And even the administration of tribal areas of ATMM state, sixth scheduled, the Tripura, Meghalaya, Mizoram and Assam will come under the category of simple majority. And other than that, the amendment into the nature of special majority, like anything you want to change in fundamental right, DPSP and other most basic areas will come under the category of special majority. Here the special majority in the sense that majority of the total membership of the house, that is a necessary point. Majority of the total membership of the house, we have to go, sorry, the majority of the total membership of the house, and the majority of at least not less than 2/3 members present and voting. Majority in the sense that 273 you are going to get out of 543, and in this 543 at least 3 to 4 to 410 at least around that people must present and voting. Based on that, amendment by special majority will be happening. And the next important thing is that the amendment by special majority into the nature of ratification of states When it is related to some matters in the name of center-state relations, ratification of the states also necessary. Here in the matter in the name of 50 states, at least 50% of the state need to give the ratification for something related to the election of president related changes in 54, 55, or executive power extension of the union and state under 73 and 162. And other than that, we can able to go into the nature of changes in Supreme Court and High Court format, or anything regarding the matters regarding the distribution of legislative power between union and state, representative states in parliament, the procedure for amendment, even under Article 368, you want to change something now. All those things will come under the category of constitutional amendment bill 1. Okay, so this is the way I can able to make a difference when you are going to look into this idea of constitutional amendment bill. So this is the nature and this is an idea. Under 107, I can able to make amendment as around, I can able to make bills into the nature of ordinary, and 110 with the speaker's certification, that is final. No even judicial intervention can able to happen. 110 money bill, 117 first class audit finance bill 1 type, 117 third class finance bill 2 type. This is the way we can able to go for the classification of various bills in as a comparison. Easy manner. Frequently questions are appearing in preliminary. You can able to manage.